The final point here is that if the disclosure of the information will outweigh, the benefit of the disclosure will outweigh any danger, the law says disclose it. What's your reading of the report?
When you played back the video, obviously
you were listening to yourself.
You saw me in there, and I had dissected it.
Yeah.
And concluded that it shouldn't have been in the first place.
That was before the report. Now we have the report.
Now we have the report.
306 pages.
That it shouldn't have been. Now, I'll go to some basic principles.
All right.
For example, before you engage a vendor, we go through a pre-qualification. The Procurement Act specifies it. Now, whilst you are pre-qualifying, there are certain requirements which are more legal or regulatory in nature. Like the company should be registered, blah, blah, blah. Then, depending on the nature of the service that is to be provided, you ask yourself, is this a regulated service or it's an open service? If it's a regulated service, what are the requirements? So, for example, if you read the ICA Act, what services they are providing qualifies as what is defined or described as public practice of accountancy. It means the institution should have been licensed by the Institute of Chartered Accountants. The question is, are they licensed? So as a procurement person, when I'm doing pre-qualification, it will be one of the first requirements I would make. Show me proof. And I can take you to the ICA Act.
You're still here on Newsfile. It is your most authoritative news analysis platform. And here on Newsfile, as always, we put Ghana first.
Section 35(1) says that for the purpose of this act, a person is engaged in public practice of accountancy if the person acting alone or in partnership with another person and in consideration of remuneration received or to be received, engages in the practice of accountancy or portrays to the public that the person is a member of the institute. Offers to perform or performs a service involving auditing or verification of financial transactions, books or records, or the preparation, verification, and certification of financial accounting reports and related statements. So B here defines what the service is and what they are doing. And C says, renders professional service or assistance in respect of matters that in principle or detail relate to accounting procedure and certification of financial facts and data. So when you are verifying volumes and all of that, it means you should be under the regulation of the ICA. The first question I would ask the GRA as the procurement entities, do they have that to prove that they are qualified to do this? Then you come to procurement, the Procurement Act. And I listened to Bright, and Bright said that there's the need to overhaul the single source. There's no need to overhaul it. It's black and white. I'll take you to that part.
It's the abuse of it.
It's the abuse of it.
Okay, so take us there and tell us why.
Now, go to section 40 of 663 as amended.
Right.
41 says, a procurement entity may engage in single source procurement under section 41 with the approval of the board. With the approval, it is a condition precedent. It requires prior approval. You don't do it and come back. Where goods, works, or services are only available from a particular supplier or contractor. So the question is accounting services and audit services only available from a particular person? Obviously, no. So it doesn't qualify.
This was their first, and the government has been their only client, so to speak, customer.
That itself is questionable and raises a lot of corporate governance questions.
As the report said, they began and they were incorporated in 2017, February. They started as SMEL. That's what the report said.
Yeah.
SMEL. And they were incorporated on the 14th of February 2017. Then June to September 2017, GRA made 3 unsuccessful attempts to obtain the PPA's approval to single source SMEL to provide transaction audit services. November 2017, SMEL then changed its name to SML. Then June 2018, SML got appointed as a subcontractor to West Blue Ghana Limited as a service provider to the GRA. Then later, the contract was extended and so on. It became the main contractor without PPA approval. You said the condition is not subsequent, it's precedent.
Yes. Now, the subcontractor part is also a bit baffling. But let me proceed and then I'll come to that part.
Go ahead, please.
So if you look at the exclusions, the basis for single sourcing, this is not proprietary.
Right.
Next one is about urgency of need. There's no urgency here. Next one is about catastrophic events. There's no catastrophic event. So if you look at the criteria for getting approval for single sourcing, it doesn't qualify. That is why on 3 occasions they were denied.
Okay.
Now, once a change of name happened, the question should have raised this thing that something is not right. Why have they changed the name? Then they decided to do subcontracting. And you guys are lawyers. Standard drafting. Provisions of a contract where it talks about assignments, contracting, novation, and the like. It also requires prior approval. So you cannot appoint a subcontractor without the prior approval of the principal. It's a standard clause. So the question is, who appointed them? West Blue. The presumption is that West Blue has already gone through the process and has been appointed and given a scope of services. So this scope of service that was subcontracted to these guys, was it originally in West Blue's contract? Because if it was not there, they don't even have the mandate to subcontract it to somebody.
How about if it got amended subsequently?
They should bring the proof.
That West Blue amended its contract and said that we will subcontract to someone else.
And if you are going to, because West Blue's contract is a multi-year contract,
okay,
it should have gone to Parliament. PPA would have given approval. So if you are going to vary the scope of their contracts with such materiality, you are supposed to go back. And in this case, looking at the amount involved, the threshold would have required that it would go as far as the Central Tender Review Board. So people would have been able to look into it. The question is, where was the Central Tender Review Board in all of this? So GRA on its own could not or should not have subcontracted through West Blue. Now, in describing the formation of the company and the principles behind it, and if you read the ICA Act, it is very clear. If the principal behind the company is a former auditor general, who left that job and immediately surfaced here.
Controller General.
Immediately surfaced here. Immediately, from a corporate governance perspective.
But remember, it's not only Controller General. He left there and went to the GRA.
Not Controller, Commissioner General.
Commissioner General.
No.
He used to be a commissioner. He was a deputy. He was
Controller General.
Yeah.
The Accountant General. Sorry.
Accountant General, yes.
The one who pays your public officers. And then moved to GRA, where he was working for the Commissioner General.
So if you look at his stature, he has the ability to exert influence. And so when you, from a corporate governance perspective, when you are analyzing conflict of interest, one of the variables is the person in a position to exert influence? And you can see it clearly there. So is it that influence that forced the authorities at GRA to do everything humanly possible to make sure that this contract comes into fruition.
Your concern will be that when this contract was going through all the processes, he was there.
He was there.
Then he left and became the managing director of this company.
Either he was there or he would have stepped out, but he still had influence. So it raises code of conduct issues, it raises conflict of interest issues before all the others will come in. Now, if you come to the Act, PPA Act again, this has happened. The media blitz has already happened. What has been the actions of the PPA subsequent to this? They have the power to revisit it. If we go to section 83 or 89, let me get there.
But they had ratified. Once the ratification came in,
That is why I'm going to it.
to the mother contract, then everything else,
that is why I'm going to it.
everything else that was sinful had been cured.
No. See, okay, so let me explain the thinking behind it. The Act says, I have these procurement methods, and you are supposed to use them in this way. At any point in time, when the board finds reason to believe that there's been a violation, it has the authority to appoint an investigator. So before an investigator would have been appointed, there is some form of prima facie evidence that there's been a contravention. Now the investigator is supposed to go and find out the details of it. When the investigator is done with his job, he brings a report back to them. When he establishes that there's been a violation, it means that a contract has already been done. So a liability has been created for the state or for the entity. So in this section, what the board is mandated to do per the Act is that after reviewing it, you can cancel it.
That's correct.
But if canceling it would create, for example, a judgment debt, which is not worth canceling, then you can ratify it. It gives other options they can use.
That's right.
But the question is, it doesn't take away the fact that there's been a violation. And the Act further prescribes in section 90 down what should be done to people who contravene the Act. My question is, in all their ratifications, and this particular board has done a lot, what has happened to people who contravene the Act?
What does the Act say should be done to those who contravene the Act? And
it specifies penalties.
Yes.
But also where they find that something on top
share them
has
directly
happened.
with us.
Okay.
And then we'll bring on Sam George, also having read the report so far. What are his views on them? This is Newsfile, it's the most authoritative news analysis platform. And here on Newsfile, as always, we put Ghana first. And you just sent in a message, say, why am I allowing Bright Simmons to poo-poo the report of KPMG and question their judgment? He applauds their findings, but their inferences he has issues with, and he should be entitled to do so. Even a court judgment is not sacrosanct, like Professor H. Kwesi Prempeh will say. Finality does not connote infallibility. We obey the Supreme Court because its word is final, but it is not because its word is infallible. Yes.
Section 92 says that, 92(1) says that a person who contravenes a provision of this Act commits an offense, and where a penalty is not provided for the offense, that person is liable on summary conviction to a fine not exceeding 2,500 penalty units, or a term of imprisonment not exceeding 5 years, or both the fine and the imprisonment.
Interesting.
Now, further, because of the IOCO Act and the SFO Act, the authority can forward the dossier to any of these, because they are procurement offenses, for them to further.
Procurement offenses for which some people have lost their office, independent constitutional office.
Yes.
For which Martin Ata-Bedu says Kisei Jabin should be removed as a special prosecutor.
So these people can also take it up and actually prosecute the person and make sure that the person gets the right punishment.
But after your reading of this 306-page report, do you say this is all that should happen, or there is something else that must happen?
There's more. The report now points you in the places you should look. And if you go and look at all of them, you find out, just like I've pointed out that the ICA Act has been violated. You find out that the Public Financial Management Act has been violated. You find out that the Internal Audit Agency Act has been violated. So you find out that a lot of other acts have been violated. What happens to all of them?
Interesting.